Welcome back to this third segment of this law session on the civil justice system. Now, we have so far looked at the background, we have looked at the reforms, and certainly one of the points that I want to start off with now is this idea of alternative dispute resolution, because that was one of the big tenets that Lord Wolf sort of rolled out on, was this idea that parties should be more cooperative in respect of dispute resolution, that if ADR is resorted to, it may at least relieve the pressure on the courts. Now, Professor Michael Zander looked at it and said that when you look at the take-up rate of ADR, it has been disappointing despite the push which has been given under the reforms. The idea, of course, there being that when you look at the take-up rate or any increase in the take-up rate, it would have to be through coercion, and that, of course, could backfire as parties would attend ADR but do not ultimately reach settlement. Now, the idea of ADR seems an extremely good one. The idea that parties should seek first to avail themselves of some kind of dispute resolution before going through the adversarial court system. Now, there are, of course, advantages and disadvantages when you look at ADR. First of all, when you look at the advantages, courts and judges are scarce, and so are public resources. They can never be made available to every potential litigant in every case, and most cases involve no serious question of law and no question of public importance. They sometimes merely involve the application of well-established principles to disputed facts, disputes which are exaggerated by distortion, and therefore it may very well be amenable to ADR. It appears parties own the process. Instead of being controlled by the court process, it allows parties greater choice and consequently greater empowerment. So when you look at ADR, it gives the parties that feeling of being in control. The disadvantage of ADR, though, is that there is this belief that the purpose of adjudication by courts is not just the resolution of private disputes. It is to deliver justice according to law, which has a public purpose of declaring and enforcing the law, thereby giving effect to the underlying values of the community. As such, it would follow that settlement, including by ADR, is a second best solution, and that every potential litigant should have an unqualified right to trial and judgment. Now, one of the arguments also may be that it may go against Article 6 of the ECHR, because have you got a fair trial, as it were, if you're looking at ADR. Now, as I say, there are advantages and disadvantages. You could legitimately get a question in an exam that says to you, is the court the only way to resolve disputes? And you would, of course, need to look at, well, no, not since Wolf, or even before, as the case may be. You would need to look also at mediation, consider arbitration, but alternative dispute resolution covers that. Anything which is done outside of the court system, it doesn't make it any less, is one of the suggestions, but one of the suggested disadvantages is that you have not availed yourself of the court system and of a qualified judge. Now, when we look at Lord Wolf's proposals, we see that it was met with a great deal of acceptance in certain quarters, but it was equally met with some criticism. And in particular, one of the fiercest critics was Professor Michael Zander, who mounted a campaign against them. And you can see, because there are two articles which I think are fairly interesting. He did this article in the New Law Journal in 1995, but he did come back 10 years later, and he did in 2009, so 10 years on from the Wolf reforms. And I will flag that up later on as well. But in 1995, he mounted a campaign against the Wolf reforms, and he seemed to argue that there was not very much wrong with the way that the civil justice system was working, and that when you look at what problems there were, if any, he said they were due to deeply inbuilt features of the English legal culture and the very nature of the task of going to trial. So he says, this is not, the delay, the cost is not about a failing in the system or a shortcoming in the system. By its very nature, litigation is going to have a certain degree of protracted proceedings nature about it, and it's going to cost you. He said by neglecting this, by looking at the inbuilt features, the proposed reforms might make matters worse. He argued that Lord Woolf had not commissioned any research on what caused the delay, but had simply assumed it was the way that lawyers operated under the adversarial system. Now, Zander referred to U.S. research, which had been conducted by the Rand Corporation, which highlighted inconsistency in judicial decisions when judges were given more discretion and case management responsibilities. Now, the new Labour government, who had come in 1997, had asked Sir Peter Middleton to review the proposed reforms of civil justice and legal aid, and he reported in September 97. Now, he largely endorsed them, but commented that Lord Woolf was concerned with managing the business of the courts more efficiently. On the whole, he took the sort of nature of the business as read, without questioning whether some types of cases would be better handled in other ways. Now, Middleton suggested that without efforts being put into settling disputes outside the court system, greater efficiency and lower costs may encourage unnecessary litigation. What he did, however, was to give support to Lord Woolf's recommendations and said that taken together, the proposals should address the problems identified. And he said the things that would obviously address the problems would be strict timetabling, whether by a standard timetable or one tailored for a particular case. This would reduce delay and uncertainty. He said limited procedures would reduce costs and delays generally, and in particular make it harder for the stronger party to deter the weaker party by using certain procedural devices. Now, in larger cases, he says hands-on judicial management, case management conferences should be able to also reduce the delay, and the development of best practices and protocols about steps to be taken before litigation would also be an extraordinarily good thing in addition to ADR. Now, he further said that a system of tiering or tracks to categorize the wide variety of disputes coming before the courts was essential, because when you're looking at cost and complexity, there must be some kind of hierarchy or rank. Now, the overriding objective should be in place to ensure that disputes could be and were, of course, resolved in a way that, of course, was fair. Now, Zander looked at it from that point, but we see in 2009, he again writes in the New Law Journal, and this time he looks at where it has all come from. He is now considering where has these reforms come to. Now, Zander, in 2009, he reflects on the Woolf reforms 10 years on. Now, he writes an article, More Harm Than Good, and as I say, it is somewhat of a reflection. Now, I would rather pause there, even though this has been a short segment, because I want to explore Zander's view now, as well as looking at what Hazel Jen has had to say in this regard. And I will take a short break. Immediately as we come back, we will conclude and look at whether these criticisms have in fact now come full circle, because we see the same person who's criticized it at the beginning looking back at how it has worked in the last 10 years. We will look at that then immediately after the break.